Hello and welcome back to Series 2 of Calm the Conflict, the Art of Resolution. Our podcast is all about resolving disputes through the process of mediation and why mediation is a good way to help businesses resolve disputes. I'm Zakia, I'm a commercial litigation solicitor, and I help businesses with recovery of unpaid invoices and also business disputes. David, my co-host.
Thanks very much. So I'm a disputes partner at E&W Law and also an accredited mediator. And we have worked together. We have worked together,
David. And you've seen me in action acting on behalf of my parties when I get really, really passionate about the case on behalf of my clients who are sat next to me. So today, what I want to talk about, because you've seen this happen a lot, and I want our listeners to get a feel of the mediation process as well. I mean, what happens when there's bad faith in mediation by one of the parties?
Sure. Well,
so tell me a little bit more about, what you've seen.
So bad faith it materialises in a whole raft of different ways. It may well be people coming to a mediation just to tick a box. It has to for some case. We tick a box, we've done it. In which case it's quite apparent to me when we start the mediation that we're wasting time. Okay, so that's at the outset. You also get bad faith that arises throughout the mediation process. So, for example, suddenly a new document arrives that has never been produced. It may be pre-litigation, so we may not have had disclosure. It may be in the disclosure exercise, and suddenly here's an email, or here's a letter, or here's a file note of some kind that no one's ever seen before to sort of railroad. A conversation is said about an agreement.
And just on that point about documentation, because I've suddenly had a thought, because one of the things in mediation is when we instruct an independent mediator is compiling a bundle of documents, which both parties agree. But then why on the day of mediation, and I've never done this, as in my clients have never produced anything to me to say on the day of mediation, by the way, look at what I found, this is going to kill the case. But the other side I've found the other side do this. So it's a document that's not been disclosed. It's never been mentioned before. It's not even referred to in the bundle where we've agreed what we're going to disclose to the mediator. And then all of a sudden they produce a document, an email, a letter that no one's ever seen.
Yep.
I think that's bad faith.
Well, it may be bad faith. It may just be an oversight. And let's not judge.
You're being too kind.
We're not here to judge. I think the problem is it does happen. I've seen it a few times. So sometimes a document suddenly appears. The difficulty is, as a mediator, it's managing expectations. And what I will say is, for example, let's take a step back. Let's make an offer. How are you going to react if you get a derisory offer? Okay, and it's the same in this whole sudden disclosure of documents, or raising arguments that have not been pleaded, or suddenly saying, "Oh, we had this conversation. There's a misrep," which has never been referred to. It's how it sits with the other side and how to handle it.
Yeah, that's what I was going to ask you. That's what I was going to say. Then, how, as a mediator, do you then go and deliver that message? Because in that moment, it won't necessarily come across as bad faith, but upon reflection, parties will see that actually that was a bit underhanded.
Absolutely.
It wasn't what we were here to talk about today, but it is. We've got to deal with it. So how do you handle that?
So not to ram it down somebody's throat to say it's clearly bad faith. What I'll say is what you need to understand, Zakia, if you're producing this thing, is how does it look? How does it look to the other side? That's managing expectations at a mediation. Things come out in a mediation, and the beauty of a mediation is that things crop up that haven't been raised in litigation. You may say something, your client may say something, I may go down a rabbit hole with that, which is slightly tangent to the case, but may be relevant. So things do come to light.
Yeah, and as unhelpful as it seems in that moment, in the long term, it's beneficial, it's helpful, because actually we've had sight of a document that we might not have had until the day of hearing, for example.
Well, if that's the case, that would be even worse. If you turn up at a court, with a new document.
What I
mean. Within the mediation process, it can be handled. And we would just say, it's a health warning. Yep, you've got the document. This is what it says. What's the provenance of this document? Why wasn't it disclosed? The other side have got to see it. They need some time to discuss it. It may be a document. It may be a new argument. It may be a third party is suddenly on the hook. For example, I did one recently, partnership dispute, shareholder dispute, where suddenly previous accountants were negligent, and this came up very early prior to the mediation, and there's letters of claim have been fired off to accountants. You need to deal with that. Was there any credibility in that? Doesn't matter for the purposes of this podcast, but it's just how it looks to the other side, the perception of how you're scrabbling around to try and find a case. So it's not necessarily in your client's best interest or a party's best interest to suddenly produce these things thinking we'll just ambush them on the day, because it needs to be handled, it needs to be managed. And I've seen this all the time. It's not always, because most of the time parties, it's a relatively straightforward thing. But arguments can be raised about misrep and duress that may not have been raised in a position statement, because that's the purpose of mediation. And I can deal with these things. Most mediators can deal with these things.
What about when parties start getting a bit when it's not really, you spend a couple of hours and it doesn't feel like it's really going anywhere? To you, it probably feels like it is moving, but to the actual parties involved, and then they're like, well, actually, we're leaving now. This isn't going anywhere, David. This process isn't working. It doesn't look like we're going to settle this. And I've got a train to catch, or
closing laptops.
Yeah, or put their coats on. How do you handle that?
I'm not sure. I mean, that is a tactic that I see all the time. At mediations, when I'm in a party, when I'm acting for a party in a mediation and or as a mediator, it's often the case that, look, we've been sitting here for 4 hours, we're getting nowhere. We're going to put half an hour, we're going. We need to leave. These are. I don't think that's necessarily bad faith. It may be, but I'm not putting necessarily bad faith. It's just a strategy that people think to do. And again, it's a managing it. So let's see where we are. Actually, we're much better off now. And my argument will be we're much better off now than we were 3 hours ago. It may not be evident in your room, but what you need to understand is I'm working with the other side. And often mediations, and you've done these things, if they're online, it's quite hard. It's a bit harder because I've got to sort of step in and out of a Zoom room. But nonetheless, I will come back and say, look, we're making progress. I understand where you want to go, and it's not necessarily bad faith. It's just people take time to digest things, and especially if a new argument has been raised, a new point has been raised, a new email suddenly materialises, and people need to think about it.
Yeah, and then just touching on the time period, for sort of 4 hours, and you've got a full day mediation, which is from about 10 till about 5 o'clock, for example. And then you're sort of getting to 3 o'clock, just gone past 3 o'clock, and no offers have been made.
Yep.
Do you then encourage parties to put forward an offer at that stage?
Yeah, 100%.
Depending on what's been said.
So through mediation training, different people get different training exercises, and there's sort of the various stages. Sometimes it is clear. It's clear to the parties and it's clear to me, because the parties will say, David, we've been here for 2 hours, we haven't heard anything, let's get on with it. And I will bring it forward. There are various ways that I can initiate that. Let's get offers going. I can also, we have to manage expectations. So I will say at the beginning of every mediation, you're going to have peaks and troughs. By 11:30, you're starting to trough. In the lead up to lunch, people are starting to trough. You come back after lunch and you're a bit more gung-ho. And the other thing to bear in mind is that the settlement agreements, etc., topic for another podcast, is always take longer. So if you want to be finishing by 6, let's get something on. Let's start drafting by 4, because it always takes longer if we've got settlement agreements, Tomlin orders, whatever it is. So that is an excuse for me to say to the parties, guys, let's get on it. If we're not going to be here till midnight, and nobody wants to be here till midnight, let's start the talking going. And there are various tools, which again we've discussed in previous podcasts, that I can initiate that process and get the ball rolling.
And then just final words on sort of the bad faith that you see and how you handle it. Just sum it up for me in one final sentence, just before we end the episode for our listeners.
Yep, I think it's managing the expectation on the receiving party. So if there is, I'm not sure it's always necessarily bad faith. You might perceive bad faith on the other side's part. They may say, oh, it just come to light, I've just discovered it. You don't know. It's not my job to judge. It's my job to handle it. And let's say, okay, we are where we are. Let's deal with it. But you need to have health warnings. So if you're going to produce something to somebody at the last minute, you've got to understand that that's not going to be well received. And we need to manage that expectation.
And I think lawyers can manage that expectation as well. A well-trained lawyer will be able to explain to its client that actually these things do crop up, and we can take time. We don't have to go back straight away. We can digest the document and take some time and find out sort of the background of it and how it came about. And why didn't you tell me that this document existed, especially if it's an email that's been sent to the other side? That also happens as well. So it's quite interesting what comes to light during a mediation process.
Absolutely. And topic of another podcast.
Yeah, absolutely. So thank you so much for joining us and for listening. Do carry on sending feedback on any of the episodes that you've listened to so far. We are so grateful for you tuning in, and we are recording more episodes for you. So make sure you are subscribed to our channel through YouTube, Spotify, and any other podcast platform that you like to listen to your podcasts on. Thank you so much.
Thanks, Zakia.
Thank you for listening. This podcast was brought to you by Right Here Creative, a video creative agency based in Oxfordshire. Check them out at rightherecreative.co.uk.